Okay, so week 4. So week 4 is going to be exploring the BC Supreme Court family rules. So basically it's going to kind of give you a what I'll call a bird's eye view of how to navigate the Supreme Court family rules. I don't know if any of you have ever went on there before, went on to, other the just Googling it, and then you get this massive table of contents. And I know for me, sometimes when I'm trying to find something, it feels like a never-ending table of contents and a never-ending document of words. So what our presenter today will be doing is she will be just kind of giving like a lay of the land for how to start a family law case, how to serve documents on somebody, the different types of court hearings that one may have. And then after that, we'll have a bit of a break, and then we'll go over any questions anyone has. So for any questions, just again, put them into the chat. Please do not direct message the presenter. The presenter needs to focus on the presentation. So you can either put it into the group chat or you can message me directly with your question. And then again, any questions that you don't get to, or we don't get to tonight, or you thought about it afterwards, you can always send an email to us. So our guest speaker tonight, her name is Clea Pia-Munson. She's from the Kitsilano Family Law Group. Okay. So once again, our acknowledgement. So we'd like to acknowledge that we are on the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh Nations. So for anyone who hasn't attended a session yet, so about AC Friends of Court. AC is a nonprofit organization. It began in 2011 with its first legal forms workshop being held in the offices of the Access Justice Center, located at 800 Hornby Street. Our legal forms workshop has helped British Columbians access affordable legal help for a variety of areas of law, including family law. At present, we have approximately 45% of our clients at Amici Curie are family law clients. And this school is the first program of its kind in BC. So again, just a shout out is the people who have helped us put this school together, and it would not be possible without the generous contributions of these individuals and organizations. So Kylene Wong from Black Roper, Don Batista, Executive Director of AC Friends of Court, Dana Cornwell, Project Manager for the National Self-Represented Litigant Project, Andrew Pillier, Director of National Self-Represented Litigant Project West. We would like to acknowledge that some of our work is adapted from resources originally developed by the Justice Education Society, National Self-Represented Litigants Project, and Legal Aid BC. So once again, AC Family Law School does not give legal advice. These sessions provide legal information only. So for housekeeping, all sessions are being recorded, and we will email the recordings to all of you. We remind everyone that recordings and reference materials are not to be distributed, and we thank you for your cooperation on this. Anybody who hasn't yet, please send in your participant agreement. Please make sure that you mute yourself, and feel free to turn off your video if you wish. Any questions, again, as I mentioned earlier, just put them into the chat box, or you can direct message me your questions. Please do try to keep details of your case limited. I know sometimes it is hard to figure out, okay, what is legal advice and what is legal information? We've gone over this a few times. So if you do have questions that have been nibbling in the back of your head, especially, so try to keep your questions keep it targeted towards tonight's presentation. If you do have a question, try to keep it general and not directly linked to your case. Respect others when communicating. And again, any questions or concerns about tonight or any additional questions that you have, please send it to info@litigantschoolbc.com. Please respect speakers, AC volunteers, and the staff and other registrants. A reminder that any kind of abusive or harassing language or behavior will not be tolerated. We reserve the right to remove any individual who engages in behavior that the course facilitators determine to be disruptive, abusive, or harassing. So I believe our guest speaker has joined us late. What I'm going to do is quickly, I'm going to pause recording.
Okay, hang on, play. There we go. Okay, so I hope everyone can see the slides again. I need to keep them big. So as Jennifer said, if you have any questions, just feel free to put them in the chat or direct message Jennifer. Don't direct message me though, because well, frankly, I might inadvertently quit Zoom or something trying to find it. So let's not mess with that. So there's a fair amount to get through today. The agenda and the objectives of today's course are all about basically bringing applications in court. If we have time, we can also talk about what happens with trials, but frankly, some of this is technical enough already. I didn't want to be completely overwhelming. I'm also hoping to take you to a couple of websites and show you around them a little bit, because personally, I found them very useful, and I hope you guys will too. So we're going to look at the Supreme Court family rules. We're going to learn different types of hearings in Supreme Court only, not provincial court. Find out where to locate Supreme Court forms online. Understand the layout of a typical family law case, and understand how to properly serve the other party on your file. So, I know you guys are having more specialized training too on the different types of issues you come up with in family law. And so you probably already know this, but just for your information, there are certain types of matters that must be in Supreme Court. And then there are other ones that can be in either Supreme or provincial court where you have a choice. So if you're getting divorced, you have to go to Supreme Court. You can't go to provincial court for the divorce. Same with property or debt division. That must also occur in Supreme Court. However, for anything to do with parenting matters, child support or spousal support, you can pick either provincial or Supreme. The only thing is that, generally speaking, if you're dealing with property or divorce, it makes sense to do everything in Supreme Court rather than bifurcate. So there are certain specific websites for the Supreme Court. Obviously, the court has its own website. I'll take you guys to that at the end if we have time. If not, you've got them in the hearing notes or the whatever this is. Sorry, it's been a long day. I'm in court tomorrow on a massive hearing, as Jennifer knows, because we work together and I just barely made it home. There's also a link to the Supreme Court family rules, which are the rules you're going to need to know for this. And then finally, for the court forms. One thing to know about this website, though, this is the official government website. So they're all up to date on there, which is good, but they're only in PDF. And if, like me, you have a Mac, it's not going to open in preview. You have to make sure you open it only in Adobe, which is really annoying. The Supreme Court used to have a great website where they link to Word versions. That doesn't seem to exist anymore. I also wanted to mention, though, I'm sure you guys have come across all of these, but useful resources, because the one thing to know about anything in Supreme Court is it is very formal and formalized, and there are a lot of issues where if you miss a deadline, for example, that can be a really big problem. And so one of the resources that is very underutilized but very helpful can be the courthouse libraries. They're open in Vancouver during regular working hours. A lot of the smaller locations, though, have limited hours, so make sure you double check before you go. I think Penticton, it's only Wednesday afternoons or something. But there's librarians, they can point you to resources. They all have computers. The computers have legal research tools loaded onto them. And so if you're trying to find any cases, if you're trying to look up the rules, if you're trying to print off forms, you can use the libraries for that. Another great resource that I can't stress enough is JP Boyd on family law. It's one of the click laws. It has this amazing how-to section, and the section has links to the court forms as well. I still use this website to make sure I'm not missing anything when I'm doing divorces, for example. It's extremely user-friendly and very well set up. It's easy to navigate. You're going to need to become familiar with the family rules, the Supreme Court family rules. You should know there are also Supreme Court civil rules, which are very similar but not identical. Don't get mixed up between them. They've got different numbering. And then finally, there's the BC Supreme Court website. They have a special section actually for self-represented litigants. It's not nearly as useful as the one on the Court of Appeal, for example, but it is not completely useless. It's worth checking out. Lawyer resources. I mean, I realize you guys are all self-represented, but again, because it's so formalized, you might want to seek even just a little bit of assistance at times. There's legal aid. You need to apply. You need to not be earning too much money, and they only cover certain issues, but it is there. There's duty counsel. They exist at courthouses. They're not always easy to track down, but sheriffs will know where they're hanging out. Unbundled services too. There's the BC Unbundling roster, as well as the National Self-Represented Litigant Project, which lists lawyers and paralegals who offer unbundling services. The national one is obviously for all of Canada, so you have to look through it to find BC. The BC one is only for BC. It can be helpful if you just need a little bit of assistance with a discrete issue, for example. Same with the Legal Coaches Association. Legal coaches will work in the background to coach you through your case. And then finally, there's the Everyone Legal Clinic, which is a relatively new clinic. It's staffed by articling students who offer usually flat rates on discrete issues. They can't do anything urgent. Don't try to go to them with a protection order you need done tomorrow. They're never going to be able to help you, but they will assist you with, for example, filing pleadings, with checking over your pleadings, with helping you prepare for court. They also help with separation agreements, for example, all for set prices. So they're worth looking out, and they'll give you a quote before you sign up with them. Key points for the Supreme Court. Read the rules. It seems obvious, but actually most people don't do this. They have a lot of information in them. Just for your guys' information, though, not all the rules matter as much as other ones. For example, I think last time I checked, there's at least 3 separate rules, all contradictory, dealing with when you need to file a financial statement. The reality is you need to file it before asking for anything to do with support or property division, but the actual deadlines don't matter enormously. On the other hand, if you don't file your application record 2 days beforehand, your hearing's not going to happen. So there's no way to know that, but if you read the rules, at least you know what the rules say. The other thing to know is Supreme Court is very formal. There's rules for almost everything. The judges are good. They're there to be fair, obviously, but they're not going to let you get away with things just because you're self-represented, and they're not able to give you legal advice. I've been in some very awkward court chambers hearings when I'm on for something else and the judge clearly wants to give legal advice and can't. So again, if you've gone to duty counsel beforehand, duty counsel is the one who can help you out with the legal advice, not the judge. And again, missing deadlines can have very serious consequences, mostly to do with having your matters not heard, which of course is not great if it's at all urgent or if you've spent a lot of time and effort with your materials. Okay, so this is a bit of a blow-by-blow on how to do a case. You guys might all have already done this, so feel free to ignore it if you have. But if you haven't yet gone to court, this is what you do as the claimant. So if you're the one who is starting off the court case, I am going to set aside deliberately the fact that this isn't always how you start. There are certain cases that have to do with other provinces or countries where you don't start this way. If there's anything really odd going on in your case to do with that, again, try talking to duty counsel or going on the unbundled services. The case I'm in court on tomorrow has a very experienced lawyer on the other side, and he started the case wrong. So again, some of this is pretty complicated. He eventually figured it out after I told him he was dead wrong, but it wasted time his client didn't really want to spend wasting. Ooh, chat. Can I open a chat? Jennifer, can you open? Anyways, sorry, my mouse is doing weird things. So the first step you want to do, though, is file a notice of family claim. The form is F3. It's also just called a notice of family claim. If you're ever talking to lawyers, just call it the notice of family claim, because frankly, we don't know what form numbers are. I had to look this up. You want to serve it. You have to serve it personally on the other person. And when I say you, I actually mean anyone over the age of 19 who isn't you. This can be a friend. It can be a family member. Don't ever use your adult kids. It's a terrible idea. You can also hire a process server if needed. If you can't find the other person for some reason, you can go to court to serve them another way, which is called a substitutional service order, usually by email, although there are other ways to do it. It's important, though, to double check, like to truly make sure you can't serve them the usual way. After this, you wait for 31 days or 30 days. We'll give it a little bit more time. If you go right away, there is inevitably going to be an issue that comes up. I usually give it about 40 days. Sorry, I have someone open up the chat thing right in the middle of my slides. Go away. There we go. Now I can see what I'm reading again. If the other side doesn't respond, that's great. This means that you can just apply for final orders using Rule 1010. Read it before you do anything here. But this means your action's undefended, which means you don't actually need to go to court. You can just file a bunch of paperwork. Usually this is when you've already sorted everything out and the only thing you're dealing with is a divorce, and frankly, you both want it. But I've got in other orders, removing someone as a guardian, for example, by this. So leads me to, as the respondent, you want to file a response. Again, I'm setting aside if you have any really odd cases to do with other provinces or countries, because there are certain things you don't want to file a response necessarily, but we're setting that aside. This is just for typical cases. You want to file a response within 30 days. So you file a response to family claim, and then you file, which is just basically probably saying no to everything the claimant has asked for. And then you file a counterclaim, which is what you're actually asking for. You serve it on the claimant, but you don't need to do it personally. You can serve it however he or she set out in the notice of family claim. Since September, everyone has to include an email address for service as well as a physical address. So you can just email it over. That said, with very important documents, it doesn't hurt to email it over and say something like, please confirm you received this. Things do go to junk mail. And you don't want to be in a situation where it turns out the other side never got it. And then finally, if you're the claimant, you want to file a response to counterclaim within 30 days, again, of getting the counterclaim. So Once you've filed all this, you can now go to court. I get later to urgent applications. You can bring these before a judicial case conference, but usually your first step is a judicial case conference. You want to book it. There's a whole practice direction. These are all found on the website, and I'll show you where afterwards. Practice directions are just basically the judges are trying to give you more information on how to do something. So they write it down. You check out the court scheduling page. Please get the other side's dates. Don't just go ahead and book without double checking. You call into the Registry of Reserve, and then crucially, you have to file Form F-19 in order to firmly reserve it. Like, yes, you've called in and it's reserved, but it's not going to happen if you don't file Form F-19. And as I said, there are a few exceptions to having to hold a JCC, but I get to those later in it. So what is a JCC? It's a mini mediation, essentially. It's a mediation with a judge, but it's not very long. It's about an hour and a half long. And because of that, you can only ask for certain orders. Usually, you can get anything by consent. Other than that, you're mostly figuring out what the next steps are. So when are we setting trial? When are we exchanging documents? What do we need to do to make that happen? You do have to file a financial statement 7 days before the JCC and serve it on the other side. If your thing has anything to do with property or support, if you're just there on parenting time, then you don't need to do this, but I don't see any case where you would ever be that. Once you've had a JCC, you get officially released from the program. Usually judges can refuse to release you, but they don't often. Once this happens, you can now go to court on other applications. So there are various types of applications. And then there's trials. These are not trials. These are generally short. They're not final, and they're on the use affidavits. So I'm just going to talk about these quickly. First is undefended. I talked about this briefly before. This is only if the other side hasn't responded, and it's generally just for divorce. Consent. A consent application is exactly what it sounds like. It's when everyone all agrees. Without notice and or urgent. There is overlap between the two, but they don't mean exactly the same thing. I'm trying to get the chat to work.
Don't worry, I'm keeping an eye on all the.
Okay, good.
Yeah.
I'll let Jennifer do that. If there's anything important, just butt in. All right.
Yeah.
Without notice / urgent, it's when it would be difficult or dangerous for the other side to know ahead of time. These are generally protection orders. Because we do so much international abduction stuff, they're also non-removal orders, which means you can't take your kid out of the province. And it's also crucially a substitutional service order, because if you can't find somebody to serve them, you obviously can't give them notice beforehand. And then there are two types of contested application. Number one is under 2 hours. This is almost everything that happens in court is this. It's a contested application for under 2 hours, happens in chambers. And then there's contested over 2 hours, and they're treated very differently. So I'll just go through them. I've set out here what you need to do for these types. Now, don't bother memorizing this. If you need to check, it's Rule 1010. Go there. It actually lists everything you need to do in the rule, which is good. You need to file a special requisition. You need to file a draft of the proposed order, and you need to sign that order. You need to provide proof that it's undefended, which these days is absolutely nothing. We used to ask them to search the court file. They started saying, please don't ask us this anymore. So there is nothing you need to prove it's undefended. You need to file a register certificate. Don't sign this. This is for a court official to sign, and it's just a court official who signs it before sending it to judge to basically say, hey, it's copacetic. There's nothing weird going on. This is an undefended case. You can go ahead and approve it if you'd like. You need to file proof of service. This is crucial because it's only undefended if it's been served and not responded to. And it needs to be personal service unless you've got that order to serve by email, for example. You need to file all relevant affidavits. There are special ones for divorce. There's form F37 if there's kids involved, it's the child support affidavit. And then there's F38, which is the divorce affidavit. Got to file these if you're asking for a divorce, or else it won't be granted. If you don't have kids, you obviously just file F38. Without it, a judge cannot grant the divorce because the entire point of this form is it sets out the evidence the judge needs to grant a divorce. So then you file all this with the courthouse and you wait. You wait somewhere between 2 weeks and 4 months. They are not going to tell you when it's done. You can call down to the registry to ask. You can also just show up. I haven't checked recently. Vancouver used to have 2 accordion files before COVID. They had a blue one with entered orders and they had a red one with rejected orders. Don't know if that still exists.
I think they still have the giant accordions.
I don't know if they ever put them back. Like, it was a COVID thing. It was when everyone thought that paperwork was contagious.
Oh, when I was there last week, it was.
They did? Okay, that's good.
I'm pretty sure. Yeah.
You don't need to talk to a registrar then. This is Vancouver. Not all the registries are the same, but if it's Vancouver, just flip through it, find your name. If the other party has a different last name, it's always alphabetical, but you should note that it's not always under your last name. Sometimes they filed under the wrong one. So just double check. If it gets rejected, you get the rejection notice. If it's accepted, you get the copy, you pick it up, and you should send a copy to the other side, just to let them know that the orders happened. Consent orders. And Jennifer, I'm relying on you. There are now 5 in the chat. It's like when your phone dings and you can't check it. Let me know if any of them are relevant to.
Yeah. We'll go through the questions after.
All right, awesome.
Yeah.
Okay, so consent. This is Rule 10.7. In case you're wondering, Rule 10 deals with applications. They're all sub Rule 10s. Again, if you look at Rule 10.7, it lists exactly what you need to file. Okay, you need to file another special requisition, Form F29. There's different requisitions. Requisition is basically just where you're asking the court anything that doesn't have a usual form, or when you're asking them to do something for you that you've already called in about. You also need to do a signed order. It's a special consent form order, though. That's crucial. Evidence that the order is consented to. Honestly, that evidence can be both of you guys signing the order. It might get rejected. They might want more affidavits, for example, but you can always just try. Technically speaking, there is no such thing as a final consent order done this way. Yeah, I had to explain that to a judge a couple of months ago. You can still try. Sometimes it makes it through. You file it with the courthouse, and again, you wait somewhere between 2 weeks and 4 months, and you check those same blue and red folders, or if you're in a different registry, ask at the family counter where you should be checking. Without notice / urgent. Again, not quite the same thing. So Rule 10.8 is without notice. 10.9 is urgent. But there is, in practice, quite a bit of overlap between them. Without notice, again, there's special forms to file. Urgent actually has to be urgent, though, eh? Like, it can't be, oh, hey, I forgot my kid's starting school next week and we haven't agreed on which school she's going to. I mean, yes, that's urgent, but also just deal with that before September 1st, right? Urgent is meant for my ex is about to get on an airplane to Saudi Arabia and I might never see my kids again. Or He has guns in the house, and I just found this out, and the cops have been called, but the kids are supposed to have parenting time, and I need a protection order. These ones have to be argued orally at the courthouse. The judge is going to want to hear about all of this. And the major difference between them is without notice. We're going to get to this in a minute, but without notice, you actually want to file it a couple of days beforehand and file a application record beforehand on the usual timelines. Urgent, you can show up. There's actually, believe it or not, a judge 24/7 in the province every single day of the year. If you're calling a judge at like 3 a.m. on New Year's, though, like that literally needs to be my ex is driving to the border with my kids. But we've gone in on protection orders after hours. They rustle up a judge for you. If it's urgent, it's urgent, and they are great at dealing with it. There's also a practice directive if you need to go after hours on how to like talk to people, because the courthouse gets closed at a certain point in time. The point being, though, that even if it's during the day, you want to go to the registry, you file everything, and then they do what's called adding you to the list. And so, yes, you're still in your regular chambers, but they hand you this giant piece of paper telling you which courtroom to go to, and you go up to that courtroom and you hand it up to the clerk in the courtroom, and you'll now just be heard along with everyone else, except because it's urgent, you'll actually get heard. Okay. Now we're moving on to by far the most common application. Contested under 2 hours, Rule 10.6. You file a notice of application and you file affidavits. You need to serve them on the other side. Now you serve them in the way set out in the notice of family claim or in the counterclaim. So you don't need to personally serve them. You can email it to them these days. If you have pre-existing cases and people haven't updated for email addresses, do it. You file a change of address form, something like that. Anyways, it's on the website. But also follow up with the other side, because frankly, sending things by email is way easier than like courier. That said, again, double check it hasn't gone to junk mail, right? Get them to confirm receipt. And if you know that the other party never checks their email, send it out by mail. You don't want to be there, have the other side not show up, and have the judge say, so was this served? And you're like, yeah, I emailed it off, a week ago. And I don't know, maybe it went to junk mail. You're just going to get bumped. The judge is just going to tell you to double check. Usually it's 8 business days. You should know a business day doesn't include holidays, Monday to Friday, but not holidays, not BC holidays. There are also, you have to give more notice if it's a summary trial, or if you're doing other kind of odd things like varying agreements or parenting coordination awards. All of this is set out in Rule 10.6. Read it carefully. Everything in this rule is business days. Bit annoying because, the 30 days for the notice of family claim, that's just 30 days. Business days, you don't count either the first or the last, like one of the first or last day. That said, I don't see anything wrong with filing a bit early. The worst is to miss it by a day, right? So just file 9 days early or 10 days early. You might save yourself a lot of procedural grief. If you've now been served with something, you got it in by email or courier mail or whatever, you need to file a response. And you really actually do, because if you don't respond, you're deemed to consent. And you need to file your affidavits. So you also need to serve them on the other side. Again, now you can do it by email, but double check they get it. It's 5 business days for almost all applications. Longer ones for exactly the same sort of applications that have longer notice periods for the applicant too. And then finally, if you're the applicant, you get the last kick at the can. You have a right of reply, which is 2 days before the hearing. Key is, though, a reply is only meant to deal with new stuff brought up in the response. You can't just restate your entire case. And that's it. You're not supposed to file any more affidavits after this, which doesn't mean people don't all the time. including me. But technically speaking, this is it. Okay, so now you've got your application, your notice of application, you got the application response, and you got all your affidavits. And please, for everyone's sake, if you're filing affidavits and this is like the 6th time you've been into court on the same thing, yes, you can rely on your affidavits 1 through 63, but maybe type out the relevant stuff again into a new affidavit, because a judge does not want this many materials for something that's set for under 2 hours. I mean, the judge is never going to have time to read it. And it needs to be relevant. It needs to be relevant for what you're asking for. That said, if all of the information in affidavit 2 is relevant and you've just updated it for affidavit 3, go ahead, rely on both. All of these documents need to be put in something called an application record. You want to read this rule very carefully. It is very badly drafted. And if you miss these deadlines, your case ends up in this weird purgatory where it's not going to get to a judge, but it's also not canceled. And you're never going to see your materials again. So it says you have to file by 4 p.m. the day that is the day before your hearing, i.e. 2 days. File it 2 days beforehand. If you miss this, you actually need to apply to get added back to the list. Which is, I mean, if you can avoid that, do it, because that's just an annoying thing to have to do. You also have to serve the index of your application record on the other party. And the reason for this is because you provide one to the court, you're going to want to make one for yourself, and then the other side makes their own. Now, literally, I'm in court tomorrow, and we got served with the application index on Friday because yesterday was a holiday at 3:56, at which point we realized they'd forgotten one of our affidavits. So, serve it early so you don't have any sort of disagreements about what's going to go in the record. Now I have to hand it up tomorrow. Like, it's just annoying. And how you figure out which affidavits to rely on, you look at that notice of application and you look at the application response and you put in every single affidavit listed there. This rule, though, also needs to be read because it says what you can't put in an application record. And that's important. All right. There's a few things you can't. You can put in a draft order if you want. It says you have to put on an extra copy of the notice of application on the front of it. Do that. That's for the clerk in the courtroom, so they don't need to retype everything. But again, read it carefully because it's very specific and it will get rejected if you miss something. It has like what you put on the title page, what you put in the index, all of that. It's not rocket science, but it is very precise. So, day of the hearing. I'm not going to get into this too much because Jennifer mentioned you have a whole section on how to comport yourself in court. But this is just specifically about these contested applications. The judge might decide to sign your order that day of. If you want that to happen, you need to get it vetted by the registry in the morning. This means you go to the family counter with a copy of your order signed by you and the other side. And you ask them to vet it. What they basically do is just make sure you haven't made any mistakes with the court file number, with your guys' names, and with any of the kids' names. If that doesn't happen, though, then what happens is the judge will make a ruling, and it's the more successful party that has to draft the order. I can't emphasize enough how useful this link right here is, the pick list. It is a list of all orders. There's one for provincial court too, but it's basically the same, just doesn't have property application. One of the things you have to set out is what orders are you asking for. But this is the form of orders that a judge wants to sign. Once you've drafted it, you send it to the other side, you ask them to sign it, you ask them to send it back to you, you then send it to the court, it then goes off eventually to a judge, and hopefully the judge signs it and it gets entered. If the judge rejects it, you make the changes the judge wants, you get it signed again, you send it back, hopefully the judge signs it and it gets entered. If you think the other side is not going to sign, one of the orders on the pick list is to dispense with their signature. Do that, because then it's just you who signs it. And a judge will grant it if you give them reasons. Like, he's never signed anything his entire life. It can be important. There are people who simply won't sign orders, especially if they haven't been successful. And then you have to go back to court again to settle it with the judge. Okay, contested more than 2 hours. It's the same general idea as contested. The big thing is, though, you need to book the day 2 months in advance. You go to the scheduling tab on the Supreme Court website, it explains the procedure. I'll take you to this when I take you to the website where you can find this. It's extremely important to make sure that at the very top, you've selected your city, or at least your registry. It is different in different places. It's basically the same in Vancouver and New West and Victoria. But smaller registries have assize weeks, right? So they don't sit every day, and they have very different procedures for all of this. And you probably have to call the registry to sort it out because they vary a lot by registry. Oh, that was the last slide. I should say, calling, you have to, in Vancouver, you call in on now Wednesday. At least they've split us off from civil, and it starts at 8:30, and you want to be speed dialing them at about 8:25 and get your friends and family to help. These are very difficult to book, and it's not because the other side isn't trying to, it's because it's impossible to get in. Last one I successfully booked, between me and all of my assistants, we calculated we called more than 1,000 times, and I got through once in the course of half an hour. So sometimes things take more than 2 hours, and that's good, and you have to deal with this, but it's not easy to do. Now, I haven't dealt with trials because frankly, it was a whole other kettle of fish. And honestly, my general advice is to get a little bit of unbundling advice if you're going off to trial, because they're even more formalized. They have extremely strict deadlines on when you have a trial management conference, what needs to be filed for a trial management conference. And then there's other materials that have to be filed certain period of time before your trial. And again, if you don't obey every single little rule about this, your trial goes off to purgatory, where there's no judge, but it's also not canceled. And then you have to go to court to reset it. It's really annoying for everyone. So, okay, I'll maybe answer some questions now, and then we can break, and then I can take you to the website, and then you can ask more questions.
Okay.
I'm now able to access the questions. Is it easier if I just sort of go through them?
It's up to you. I mean, I can walk you through it. So I noticed you mentioned a word, bifurcate. Can you explain what that means?
I?
Yes.
Oh, it's when you split your case up. So your case, maybe you're asking for divorce, you're asking for property division, you're asking for spousal support, you're asking for child support, and you're asking for parenting time, you're asking for everything. Well, maybe what you actually want to deal with today is just the parenting stuff, right? And so you can deal with that in a contested application and set aside the property stuff for the trial, for example.
Okay. Sorry, I'm just gonna like put it back on this screen here.
Perfect. Thank you.
Okay. So, and then you mentioned for JCCs, they have to fill out a form F-19. What is the title of that document? Just so people know.
Judicial case management.
Notice
Or
of judicial case management. So for anyone who has to, once you have booked or successfully booked your judicial case conference, so that's when you called in, you've said, I'm looking to book a judicial case conference on, I'll make up a date right now, October 15th. What happens is they'll ask for your information. They'll want to know who the parties are, what your court action number is. You then have to file what Clea said was a Form F-19, which is a notice of judicial case conference. So that's the document that officially sets the case conference for you. And then
yeah,
so
so the reason I listed that number is because frankly that's a very long title, but also because as I'll show you on the government website, they list everything by both court like F whatever number and by title. So if you do control find, you can either find it through F-19 or through notice of judicial case conference, which is kind of nice.
Okay, so another question somebody had. So they said they have seen cases where the other side's lawyer got a date, like a court date, without asking the party, so the self-represented party. Is there a way to call that lawyer out on that?
It really depends, right? So I would say if actually you can meet the deadlines and you also want this done and you're available that day, don't cause a stink about it, right? Because it doesn't really matter. The bigger issue is if you are legitimately not available that day. And if that's the case, you need to get in touch with the other lawyer and say, I'm not available. We need to adjourn this. But you do kind of need to be reasonable about adjournments, right? So that's when you delay the hearing. The other side's probably not going to agree to delay it by 3 months, right? But if you're getting in touch and you're saying, look, I don't know, I've got a dentist appointment that day that I set up like 4 months ago. Can we just delay it by a week? The other side should say yes. And if they don't, send a friend on your behalf and the judge will delay it and you'll probably get costs. I always try to double check, right? If the lawyer sets it, don't just send back a super angry email. Just say, you didn't check with me. I'm not available, but I am available on these like 16 dates. So that's how I would do it. Once you're at the court hearing, the judge doesn't care unless you're not available, right? But if you're both there and you're both prepared to argue it, the judge really doesn't care if it was set without notice. From your end, though, it's just a way of increasing civility in the justice system. Just double check with the other side or their lawyer for their availability. And again, if the lawyer's like, I'm sorry, I'm not available for the next 3 months, you're like, well, too bad, so sad. I'm going to set it anyways, but I'm giving you lots of notice. But if they say, look, I'm in court that day, but I can do it the next week, set it for the next week.
Okay. So someone had made a comment about I guess what would you do, what could you do if an opposing party, so let's say you have a JCC and the opposing party files and submits their financial statement at the very last minute, I'll say for an example, maybe a day or two beforehand instead of the usual timeline of I believe it's 7 or 8 business days off the top of my head.
I think it's 7 days, 7 regular days.
7 regular days. And
honestly, that's one of those deadlines that doesn't really matter.
So if the judge accepts it, if let's say the party's like, I haven't had a chance to actually review this yet.
That's a bigger deal, right? But it depends on how useful the JCC is going to be. If your only issue is child support and the other side, you really needed to review their tax returns, you're not going to agree on anything at the JCC if you get it the day before, right? If it's a matter though where the only issue is some sort of complicated exemption argument for property division that's clearly going to need to be sorted out at trial, and you get it the day before, the important thing is you got it. My colleague was at a JCC with another lawyer a couple of weeks ago, and we never got the financial statement. What we asked for at the JCC was an order that he provide us with one. So yeah, it's, again, there's no way to know, but that is one of those rules where the timelines aren't nearly as strict.
So for setting a notice of application, who decides or how do you decide if it'll be over or under 2 hours?
Yeah, good luck with that one. Strictly speaking, it's the applicant who gives a time estimate, and then the other side agrees or disagrees. And then on the day of, if you truly think it's going to last a day, you say that to the clerk, and the clerk basically rolls their eyes and you probably don't get heard. It's hard. It's hard to estimate time. I've been doing this for years now, and I'm still not always accurate. So I think it is the applicant who decides if it's over or under 2 hours. If the other side shows up with, 15 affidavits and 4 binders and says, I think this is a day, the judge is probably going to agree with them. But again, you need to be a bit realistic. If you're saying, I think it's going to be over 2 hours just because you don't want it to get dealt with, judge isn't going to have a lot of patience for that. If you're looking at it and you're like, you're actually asking for like 16 separate distinct orders, or like tomorrow, my jurisdictional hearing, and we've set it for a day because it's complicated law. I mean, I think I'm going to be talking for over 2 hours myself tomorrow on it. So there's no real rule on this. You both need to tell the clerk day of, though, what your estimate is, and you need to be fairly accurate about it to the best of your knowledge. We all kind of aren't great at estimating how long we're going to talk for.
Actually, there was a judge, I attended a presentation on, a judge said to also, so this is a good rule of thumb for everybody here, is to factor in how long you think it's going to take to present your position and how long it'll take for question and answer, because the judge will have questions and answers too. So sometimes overestimating can be better than underestimating.
And actually, further to that, it's not just yours, it's the other side's. They want to know how long in total you think the two of you are going to be talking and answering questions. And it is definitely better to overestimate somewhat than to underestimate. There's nothing like somebody saying, oh yeah, don't worry, this is a 5-minute thing, and they get up and blather there for 15 minutes, and everyone else is like, mine is actually 5 minutes, I just don't want to be here. But likewise, if you think it's going to be a day, you need to say that, because I have been in court and we both estimated 2 hours and it took a day and a half. And man, I can tell you the judge was not happy with us. He asked a lot of questions. It wasn't really our fault, in my opinion. But he was very unimpressed.
Another question. So this one, I think it's a little bit of a, hold on, let me see. It's two comments here. It's about financial statements. So one I think might be a little bit difficult to answer, because it's, what is the criteria for the Form F8? So I don't know if that's about what you put in it or why you need it. And then
read the form. Like, it sets out at the top what you need to do to fill it out and which sections you need to fill out depending on what you're asked for. And I see here it says, does it need to be notarized? Yes, it does. It's an affidavit. It's a weird affidavit, but it is in fact just an affidavit.
And you can, if you can't find a lawyer or notary, you can get it done at the family registry. They charge $40, I believe. So you can get it sworn. It's called sworn, but you can get it sworn there, because all the registry staff are what are called commissioners.
Yeah, and that's for any affidavit, not just a financial statement.
Can someone be served while on vacation? So I don't know if this is about, like, if an opposing party is like, I'm going on vacation and then goes away, or if it's a lawyer that goes on vacation.
So again, there's no rules about this. Yes, you can serve someone on vacation, full on. The thing is I think you need to judge Again, how urgent is it actually? And can you just wait until they get back? Because there is nothing like being in the middle of the wilderness and getting a frantic phone call from your paralegal to say, we've been served with something that's happening while you're away, for you to kind of personally hate the other side. And you don't really want that with the other lawyer, right? Or the other party. So if you serve someone and you get a bounce back that says, hey, I'm on vacation for the next 10 days, just set it down for 10 days later, right? I mean, again, but use your judgment. If you're going in for a protection order, we had a case where a lawyer would go on vacation for a month and wouldn't have anyone covering. Lawyers usually have someone covering their files, right? She didn't have anyone covering, and we needed to go in for a protection order. And we were like, what do we do? Like, literally, we got no way to serve her. She turned off her fax machine and locked her doors. So use your judge, probably be someone covering. If it's not urgent, just wait.
So what if you serve someone by email and get an ask in that same email for them to confirm? They don't respond. You find other ways to follow up on that text message, further emails, even like a handwritten a letter or something. What could you do next?
Yeah, I'm pretty sure this is why my affidavit didn't make it into our petition record, is because we served it by email and they didn't respond. It's a real problem with email service. And so again, if you've got a ton of time to do this, serve it by email, yes, but give yourself time to also mail out a copy, or do registered mail if you think the person will actually pick it up. If you don't, just do regular mail, because then if they don't show up at the hearing, you can say to the judge, look, I served it by email, I served it by mail. They're not here. That's not my problem. This needs to go ahead anyways. They clearly had notice.
For the application record, do you need to number each page?
No, you number each page of each document. So the notice of application has page numbers. The application response has page numbers, and all of the affidavits, dear God, have page numbers, and those are very important. But the application record has tabs. So tab 1 is the application, the notice of application. Tab 2 is the application response. Tab 3 is the first affidavit. You don't renumber everything for the application record.
Okay, so this one, it's a 3-part question. So I think for part of this question should actually be emailed to info@litigantschoolbc.com. So I think it's asking for resources in Victoria Island, which I can look into and give you some resources for. So part of it is, can I call can someone call the opposing lawyer to see if they're still working at that firm instead of asking their lawyer to do it? So if they're represented, can they directly reach out to the opposing counsel?
You can, but nobody's going to talk to you. And it's because as lawyers, we have extremely strict professional requirements not to talk to litigants if they're represented. That said, anytime you move firms or anytime you get a new lawyer, you have to file a change of address or a change of lawyer form with the court. So you can go down to the courthouse and search your court file and see what the most up-to-date address is for the other side. And that should tell you if the lawyer is still at his old firm. If the lawyer forgot to file all this, well, you can merely go ahead and serve them at the old place, and that's kind of their problem. So, but if you tried talking directly to a lawyer and you have your own lawyer, the other side's lawyer is not allowed to talk to you. It's a disbarable offense. None of us are going to do it.
Yeah, I think for the other 2 questions, I would recommend just emailing Litigant School directly, and then we can see what kind of resources we can give to you for those 2 questions. So if you are trying to appear remotely, how would you submit that request?
It is a special record. It is a requisition. I think there's a practice direction on this actually. And you can call the registry to ask. The reality is the court has made it almost impossible to appear remotely, unless it's by consent or for something like a JCC or a trial management conference. It's a real problem. I'm not going to downplay it. It's a real access to justice issue. There is a requisition. You need to file it really early because of the change in like requiring emails, the system is completely bogged up for the past month because they're trying to process thousands of change of addresses to include emails. So yeah, things are taking forever. So there is a requisition. It's a special requisition. And you really need to set out the reasons why. And if the other side agrees, that's great, because if it's by consent, the judge is much more likely to agree. But I'm not going to downplay it. It's a huge problem.
And I'll just find that. I think it's on I'm pretty sure it's on the Supreme Court website, that exact requisition.
There's reference to it. And again, there might now be a practice direction. Duty counsel would know for sure, though. You just give a quick call to duty counsel, they would have this resource at their fingertips.
And sometimes, and so take this, I don't want to say take it with a grain of salt, but don't cling on to my words. Sometimes the registry, they can be very helpful. Again, it's going to depend on the registry that your court action is attached to. But sometimes if you a quick call, you can ask them, what exact form do I need to do this? And sometimes they can point you into the right direction. Vancouver Registry,
it depends.
They're a little bit,
I've had
hit or miss. Sometimes,
yeah.
Sometimes they're really good at just, laying it out for you. And other times they'll be like, they can be a little bit reluctant asking, but it never hurts to call and ask.
And I think it's really important to remember that they have a kind of terrible job, and they often get blamed for problems with the legal system that really are not their fault. It's structural problems. So I have found that the best results I've ever gotten out of the registry is when you approach them in an extremely respectful way. If they can't do something for you, it's because they're not allowed to, not because they're trying to be jerks. But I think people forget that because they're the front-facing part of the legal system, and sometimes they have their backs up because they're used to being yelled at, tragically. So just if you're really respectful, sometimes you can get a lot more out of them.
So for somebody who English is not their first language, is it possible to ask the court to have the hearing in their specific language? Or what can one do to adequately represent themselves when English is not their first language?
So no, you can get interpreters. I see here though, because I've hacked in, I can access the chats. You're asking specifically about French. The reality is the new Divorce Act, like a couple of years old, mandates that every province have bilingual services for family law. The problem is they gave everyone other than New Brunswick, which is already bilingual, a massive amount of time to come up with the forms and the judges. So right now, you can't do it in French. It's really annoying, frankly, but you have to do everything in English. And if you got married in Quebec, that includes translating your marriage certificate, even though like dat and date should be easily figured out. It's coming. It will soon be allowed, but I'm pretty sure BC was given something like 5 to 10 years to come up with bilingual resources. For other languages, it's never going to happen. It's always going to be in English or in French, and you might need to find an interpreter to assist you. There is a French language association. It's got a really long title, Association des juristes francophones de la Colombie-Britannique, or something like that. If you search there, they have French-speaking lawyers. The unbundled roster lists languages any language that a lawyer or paralegal has listed as a second language. So again, if you need unbundled services, that's there. Legal aid actually also gets us to list languages we are competent to provide legal services in. So you might be able to find assistance.
This other question, I don't know if you can answer because I think it might be bordering on legal advice. It's regarding having two cases in both levels of court.
Yeah, I'm reading it right now. I think you need to talk to duty counsel or unbundling because it's complicated. I mean, you obviously know that, right? There are ways to join cases. There are ways to transfer provincial court to Supreme and vice versa. It's pretty technical though.
If it's only one order just for child support, is it safe to say it's under 2 hours? So I guess if it's like,
yeah, I mean, I think so. If somebody has excruciatingly complicated corporate income or dividends, or you're trying to impute a bunch of income, maybe not. But honestly, if it's that one issue, I don't see how it could be more than 2 hours. In any sane world, in any world where the judge is still going to be listening to you.
So this one's about witnesses at trial. So if they're in different countries or different provinces, do the courts allow for them to appear remotely? And would you do this through a requisition?
So there are ways to appear remotely. I've done it way back in the dark ages where it was by telephone. There is a requisition. Again, it's easier if you can get it by consent. These are the types of orders, though, you can get at a trial management conference. So at the trial management conference, you can get permission for parties out of province to testify remotely. These days, it's usually by MS Teams, and it's regularly granted, this type of order. Other province, other countries, they're not going to expect someone to fly over here from Europe to testify. So yeah, do it at the trial management conference if you can. Do it by consent if you can, but if not, if it's an important witness, the judge will allow it. And I see there was actually the lawyer who served the self-represented person while on vacation. That might be a bit actually more complicated because I don't know if the lawyer knew you were away or not. But in any event, that lawyer should have really reset it for once you were back home. And if they didn't, that's really unfortunate.
So this is about financial statements. So if I'm understanding this correctly, it sounds like certain parts of the financial statement were omitted and filed. How would they approach? Oh, you got it? You got it.
Yeah. So again, take a really close read of the financial statement. On the first bit of it, it lists if you're asking for this type of order, fill out part 1, right? So double check that they actually need to bring it all up. If they do and they didn't, you can ask at a judicial case conference for an order that they provide the details. Or at a trial management conference, or you can bring an application for that. I mean, you can also write them a letter to say, hey, if they refuse to give the information, you can ask the judge to what's called draw adverse inferences, which is to make assumptions that are beneficial to you because the other side hasn't done what they're supposed to do.
And so for people who have questions about the financial statement itself, we are going to go into more detail about the form. So what each part is, this is just me talking off the top of my head, but it should be, so we're going to probably go into like what each part is, you know, how do you know which part to fill out? So I believe that's going to be in week 8 is where we're going to go into financial statements in more detail. So anybody who has very nitty-gritty questions about the financial statement, if possible, if you can hold your questions until week 8, which I know is, you know, for some people, if you need to file one next week, it might not be beneficial, but if you can, if you can't, again, just send those questions to info@litigantschoolbc.com, and we'll do the best we can to like help give you some guidance on that, whether it be reaching out to the presenter in advance or sending you resources again. So for anyone who wants to know more about financial statements, we'll be talking about it in more detail in week 8. And then for self-represented person. So for finding Word versions,
I'm going to show you one resource after the break. JP Boyd's on Family Law has a lot of them. They don't all exist in Word. The other thing I'd recommend, though, is going to courthouse libraries. They can often help you print things out in the appropriate format. I agree with you, though. The format is terrible and it is not user-friendly. And if you have a Mac, it actually just doesn't work. I can't fill these forms out on my computer. So, but double check the libraries. Libraries can help you with a lot of this. And I am going to show you the JP Boyd one still has a bunch of them in Word. So they do exist. They're kind of hard to find. The library, though, has amazing resources. They also have sample clauses you can fill in.
Supreme Court child support order rather than going to provincial court. So for the difference between going to Supreme versus provincial for child support, is there any specific benefit? I think I
think it really depends on what else is going on in your case, right? If you're dealing with property division or divorce, you probably want to just do everything in Supreme because you get it all done at once. If you're only dealing with parenting and child support, provincial court is often a lot easier for self-represented litigants to navigate, although lawyers hate it deeply because it doesn't have proper rules. So we can never figure out how to do anything. But it is truly your decision. Judges in both provincial and Supreme are fully capable of hearing an argument on how to impute income and whether it should be imputed. I've gone to both courts on that exact issue.
So it's for a trial management conference. Do either party have to have a list of all their witnesses? What else does one need to prepare for that conference?
So the trial management conference requires you to file a trial management brief, something like 7 days beforehand. And if you miss that deadline, you're in a lot of trouble. And that brief is formal. I don't remember what number it is. It's a form. And you have to fill it out correctly. And it lists in it what orders are you asking for specifically and why. Who are your witnesses and how long do you think they're going to take to testify? Who are the other side's witnesses that you know about and how long are you going to take to cross-examine them? What experts, if any, are you going to be calling? What evidence are you going to be relying on? What law are you going to be relying on? And how long do you think your opening and closings are going to take? All of this is because, congratulations, you've booked a trial for like 5 days, and now you want to call 25 witnesses. It's not going to work, right? It's the point of the trial management conference is for the judge there to assess whether your time estimate is at all reasonable. And if it isn't, then your trial is not going to happen. And then also to make sure that everyone is on track where they know what they're asking for and they know what they need to do to prepare for trial. So there's in the rules, check the rules. There's a special rule on trial management conferences. It tells you what sort of orders you can get there. Right? One of them is for witnesses to appear remotely, right? One of them might be if you're still missing, part 4 of the financial statement to finally get that before trial. You can demand will say statements from witnesses. So what is the witness going to testify about? You can demand exchanges of documents if you're still missing some. So it's, again, the rule sets out what you can ask for. And you need to read it beforehand. Don't worry. It's not going to be something where someone gets imputed income at a trial management conference. It's all just procedure, really. But that trial management brief, They are cracking down on that. If you are 5 minutes, like 4:05 on the day you're supposed to do it, it won't get filed, and your trial management conference might not happen, which means your trial won't happen. So it matters. And then there are other forms you have to file for trial. Again, it's very formalized, but it's all set out in the rules.
Okay, so I think we've gone through all the questions. So we're at 6:50 right now. Do you want a 10-minute break, 15-minute break? How you feeling?
I'm good. I'm hungry, so I'd rather have a shorter break so I can go eat if we end a bit early. So 10
Or
minutes would be
how,
good.
actually, how
Or-
does everyone feel about does everyone want to take a quick break, or would you like Clea to kind of start going through the Supreme Court website? We just put a yes, no, maybe so in the chat.
We have one vote.
Continue. How do people feel it just continue and then we can end a little bit earlier?
All right. I see a couple continues. So
We're
it
gonna
shouldn't
take that as a we're gonna take that as a yes. Continue.
we got a majority of 3. I shouldn't take too long. I just want to show you a couple of websites that I have found particularly helpful. So I'm going to share my screen here.
We're gonna stop sharing.
Right.
It's gonna resume.
Okay, so the first resource I want to show you is this JP Boyd on family law. I honestly Google JP Boyd's he's a lawyer. He's the one who started this. He's amazing. I Google JP Boyd on family law. That's how I find it. It is a click law wikibook. But if you just try to Google click law, you end up at some infernal legal aid offshoot website, which has a ton of resources, but not this one. So if you click on it, it's actually a book. You can actually download the whole thing as a PDF. I used to have that on my desk when I first started out. But it gives you an introduction. What is family law? It gives you the legal system, resolving problems, all the rest of it. It also has this how-to section. This part is great. So how do I get divorced? How do I figure out if I'm still married? There's more how-to topics. I would highly recommend this. You know, how do you do an affidavit? Prepare an affidavit, prepare a supplemental, fix. So again, how do you address the judge? How do you address the lawyer? All of this is very useful. The other great thing that JP Boyd has done, though, is he has court forms and examples. And so when you go here, it's listed both by the name of the form and it's listed alphabetically, which is not how it's usually set up. Usually it's set up by form number, but anyways, and so you'll see some here that like you'll probably never use, like an acknowledgement of payment. I've literally never heard of that one before. On the other hand, affidavits, yes. And they have PDF versions, and they also have a blank HTML version. They have a completed PDF example, and then they have a doc, so Word document version. So if you look at the PDF one, sorry, my internet isn't great at home. It shows you just an example of one that's filled out. And so you can kind of see what it looks like. And then you can do your own. This is probably the best place to find your Word document versions of these. There is also, though, and again, I just Googled BC family law forms. What you want is the Supreme Court family rules forms, because you're in Supreme, according to this webinar. There are also, though, like legal aid has one, find a family form. Supreme, provincial, they have them, right? And they have what it is, but they only have the PDF version, but they still have it. But the government website, is ignore all this top stuff. See, Adobe, why on earth can't they come out with it for Macs? They have everything again. They have all of them. They're all PDFs. They're all those terrible PDFs, but they have literally, and this is up to date. You can trust the government website to be up to date. JP Boyd might not be. They have literally everything in here though. So if, for example, I'm trying to find the divorce affidavit, but I only know it's called F38, I'll find that affidavit, desk order divorce. And then finally, the Supreme Court website, you can see which ones I check. Again, I just Googled BC Supreme Court, Google BC, otherwise you end up at the Court of Canada, the Canadian Supreme Court. They have, you know, a bunch of little tabs over here, obviously. The important ones you want, though, are the rules, procedures, orders, and forms. If you go to the family practice directions, I mentioned that before, it lists like how to do an adoption application, if that comes up. How to appeal from the provincial court, applications made by requisition, right? Model orders, that's the pick list basically. Master's jurisdictions, you know, a lot of this you won't need. Gowning policy for counsel, like you definitely don't need that one, but they are here. Chambers practice, you know, that one is important. So why not just read it? So it tells you what to do, right? The other thing they have here is, where is it? Model orders. No, this is not the pick list. Pick list is somewhere on here, but honestly, Google family law pick list and it'll pop up. Acts, rules, and forms. This gives you a list, a link to the rules. All of these rules I've been talking about. Sends you to all of them. How do I start and defend a family law case? So that's that, right? I was talking a lot about Rule 10, so I'm just going to scroll down. 8, 9. 10, obtaining orders other than at trial, i.e. by application. Choosing the appropriate procedure, place it's heard, chambers proceedings, affidavits. What is an affidavit? And then usual, right? 10.6. That's the under 2 hour one. See, there's a lot of rules though, and it doesn't hurt to read them once. Consent applications though. And then if you click on it, it will literally tell you to do what my slide told you to do, which is to file this. Right? And that will be a link to the most up-to-date version of the rules. They do change, so you want to be reading the up-to-date version. There's also a tab on the left here for self-represented litigants. It's not actually horrifically helpful, but it lists links to some organizations. Duty Council. Duty Council can be very helpful. And then information about different education you can have. And then where is it? Scheduling. This is the last one I want to show you. So scheduling, it defaults to Vancouver, I think, because it's the biggest. So if you're in Vancouver, this has very practical information, right? Online booking for judicial case conferences. Oh my God, that is new. Like very new. I didn't know this was a thing.
I think it's like when because they did change some stuff around this past month.
Yeah. No, I know you got to go through CSO online, which is just a pain. But MVA is motor vehicle accidents. Don't click on that unless you got one of those. But trials, right? So this will show you for 3-day trials, if that's what you need. Sorry, I'm just opening them up in new tabs. These are available dates. Starting in March. Conferences. The Judicial Case Conference. Available date. Case management, sorry. Case management is judicial management, no, Judicial Case Conference. Some of these are civil. JCC's family, that's it. That's weird. Usually there are a lot more dates. But anyways, they must be updating for the new year. The point is there aren't a ton available. So if you're trying to book a JCC, this is it for now. But check back regularly. They do update it. Chambers, assize chambers dates, not relevant in Vancouver, but booking lengthy chambers. There's never a date here. Yeah, never. I don't know why they bother having that. Because booking long chambers, this is what you need to do. This tells you what to do. And it tells you when to book for, right? So if you want to book in September, you needed to call in on July 11th. All of that is passed by now. If you want to book in December, you call in next week. If you want to book for next January, you call in on November. It's the second Wednesday of the month. And then again, notices down here. The after hour, that's for civil. I think it covers family, but in any event, it tells you who to call, basically. Not all of this is relevant, right? Some of this is like 525 detention reviews. That's criminal. You don't need to ever deal with that. Trial brief information, that might be relevant. Hearings using videos. Here we go. Court video conference request form. I would just take a look through this, and then crucially, if you're not in Vancouver, if you're in Vernon, change it to that. And it will tell you how to, it'll show you the assize weeks, right? It'll show you when the judges are sitting in Vernon. It will show you when you can book a JCC in Vernon. If you look at Victoria, it's going to look a lot more like Vancouver. Trial and chamber dates available though, 1 to 10 days. New West is again much more like Vancouver. But if you're looking at littler places, don't forget to change it, because there's not a lot of point in booking a lengthy chamber in Vancouver if your case is actually in Dawson Creek. Okay, that was it. I would highly recommend playing around a little bit on this website. It's not the greatest, but it does have quite a bit of information available.
I saw some people asking about sending links. So close that for a second. Close that too. Yeah, so what I'm doing is I've been writing out some of the links and resources that Clea has been referring to. So when you get the recording of the video, I'll include the links in there as well.
Is everyone getting a copy of the
PowerPoint presentation?
PowerPoints, yeah.
Yeah, so that'll be
they're all listed in the PowerPoint presentation.
Yeah,
somewhere.
So
Useful
it'll be
Resources has JP Boyd on family law, the link to it, and the BC Supreme Court website. I might have forgotten the link to the forms on the government website because frankly it's annoying to use, but oh no, it's there too. BC Supreme Court specific websites. So they're all in my PowerPoint presentation as well.
Okay. And then for anybody, if they haven't been receiving emails of the previous week's recordings, please email info@litigantschoolbc.com. We've been sending them out, but if you haven't received anything, either check your spam mail or send us an email and then we'll re-forward that email to you. And then I believe we have one more question. So it's regarding booking a JCC, or sorry, booking a trial at a JCC. Can you do that? Can you book a trial at JCC, or do you have to do that separately?
Yeah. It's one of the procedural orders that you can get at a JCC. Let me see though here. So that's what happens. You have so many forms open. Nope. Here we go. No. Sorry, hang on. Let me close all of these. Not that. There's the pick list. I guess that makes sense. Supreme Court Civil and Family Law Orders pick list. Acts, rules, and forms. Here we go. Sorry. If you look at the Supreme Court Family Rules, and you look at case conferences, and the reason I say to like just read the rules is because in here, one of the things they list in the rules is what happens at a judicial case conference. And so this lists what a judge can do at a judicial case conference. They can make one or more of the following orders, right? Try to settle things, make consent orders, mediate, refer to a mediator, basically, or a family justice counselor, but also make orders to amend your notice of family claim if you have a spelling mistake on it. Make orders requiring particulars. It's just a fancy way of asking for details. Examinations for discovery, you can make orders for that. Direct that any applications must happen within a specific time. And then elder, reserve a trial date for the family law case. So again, if you're going to a JCC anytime soon, take a look at this and just double check. You might want to ask for some of these orders. I know they're in convoluted legalese, a lot of them, and they give a bit of a headache to read through them, but they are worth double checking. And then trial management conferences, you see it's linked. That's rule 14-3. If you want to figure out what you can do at a trial management conference, take a look there.
Then there is a second question to that. Can you book a trial before you book a JCC?
I think so. I mean, the way you book a trial is like booking a JCC. You check what dates are available and you call in and you reserve it. The thing is you need to figure out if the other side's available and if they agree on length. Because without that, you're not going to be able to file the trial
notice of trial.
Yes, I was going for trial brief, but it's definitely not that. The notice of trial. So you can book it before the JCC, and dates go fast, like really fast. There's not a lot of availability for trial. So yeah, you can book it, but you have to make sure the other side agrees with you on how long it's going to be and when it's going to be, because without that, you're not gonna be able to book a trial. So one of the reasons why it doesn't usually happen before a JCC is sometimes the first chance the parties get to sit down with a judge in the room and see if we can actually sort any of this out without a trial. Because trials are emotionally draining, very expensive if you have a lawyer, and not a great way to resolve your issues. Whereas if you're sitting with the judge, you're like, actually, I think we can agree on X, Y, and Z, then your trial is going to be shorter, if it's going to happen at all.
All right. So we're at almost 7:10. Anyone have any? Oh, thank you. Anybody else have any other questions that they want to ask tonight? And again, if not, if you can't think of anything right now, but something pops up tonight or tomorrow, you can again send those questions to info@litigantschoolbc.com. One little tip I do want to point out. So if any of you have seen just a typical court form, normally at the tippy top of that form, they'll have like form. So for instance, form F8, then they'll have in brackets a rule. So if you look up that rule, like you see that rule number and you go onto the Supreme Court website, it'll show you, it'll explain what that form is. Well, semi-explain what that form is about. There we go. Leah's gonna
Here, allow me to
demonstrate.
show you. Oh, wait, huh?
You're on the, go on the JP Boyd one.
Yes, I was going to say, allow me to show you when I can't, because I can't open it on this computer. Forms. But yes, what Jennifer is saying is extremely helpful. So, affidavit doc. Can I open?
I think you have to.
Slowly. Here, this is what she's talking about. At the top of every form, it tells you the name of the form and which rule refers to this form. It's very important because sometimes you're trying to figure out what on earth you're doing with the form. As Jennifer said, this gives you a link back to the rules, and vice versa. If you were to look at rule 10-4 sub 2 and sub 7, it would refer to form F30.
And for everybody else, what I can do is when I send the email with this week's recording, I'll do a little screenshot for you so you know what I'm talking about. But yeah, it's a good little tip to understand what that form is and what rule they're talking about. So it kind of helps match the two together.
Yeah.
All right, so if there's no more questions, we can end early tonight. And someone has pointed out that it's Thanksgiving next weekend. So everyone have a great Thanksgiving. Thank you all for attending tonight. We greatly appreciate it. I know sometimes on a Tuesday, for almost 2 hours, not easy to get to, and to sit through that. And, you know, thank you, Clea. Thank you so much for spending 2 hours talking. And sharing your knowledge on the Supreme Court rules, and also doing this the day before a hearing. So I greatly appreciate that.
Yeah, no worries.
Okay, I'm going to stop the recording now. Yes, are you sure you want to stop the recording?